All right, welcome back to another episode of the Jon Gil Podcast Show. And we're super excited to have on Mike Bradley with us today. He's attorney at law. He has been practicing law since the 80s, and he was an administrative law judge, practiced criminal and divorce cases. He was a general practitioner. And since 2004, he's really been focusing on real estate-related law and probate and just in general real estate related matters. So, Mike, thank you so much for being on the show.
Pleasure to be here.
And Mike, can you, on this episode, I really want to talk about the eviction process. We're going through some crazy times, and especially here in Cook County, they've passed new legislation on eviction, on the appropriate eviction process. Can you shed some light on how the eviction process works here in Cook County?
Well, I can tell you how it used to work.
Okay, let's hear how it used to work.
Right, and we all have to roll with the punches, so to speak, with the moratoriums and items like that.
Yeah.
But the eviction process in general, I would say there's two types of evictions. One is by what I call by right, and one is for cause. The one by right is the lease is up and you want somebody to move. It's not that they haven't been a good tenant. It's your property. Mm-hmm. You want the person to leave for whatever reason. You want to rehab the unit into condominiums, or the building into condominiums, or maybe you just didn't like the tenant, or you want to bring a son or daughter or their family into the unit. For whatever the reason, you just want them to leave. The lease is over. They've done nothing wrong necessarily, but you just want your property back. That's what I call eviction by right. And then there's the eviction for cause, which I'd say is about 80 to 90% of the evictions, which generally involves non-payment of rent. So the person has fallen behind in rent, and then the landlord will give them a notice.
Got it. And let's talk about those notices for both scenarios that you discussed. The 5-day notice is for the eviction of cause.
Yes, usually for non-payment of rent. It could be for other things, but I have never seen somebody put out of an apartment for having a dog,
right?
In court. Now, I'm not saying it's never happened. I'm just saying I haven't seen it. For cause is generally non-payment of rent.
Got it.
And yes, there would be a 5-day notice. And the 5-day notice does not mean you're 5 days late with the rent. You can serve the 5-day notice on the second day of the month. What that gives the tenant is 5 days to cure the rent deficiency. So if they're behind $1,500, the landlord serves a 5-day notice. By the way, it must be served to them personally, not slid under the door. And it must be, or to someone who lives in the unit 13 years of age or above.
And not posting it on their door either, I would assume.
Yes, that's true. That is okay. Not the courts really frown on any type of notice. You basically need special permission to go beyond that. And normally, even though it can be inconvenient, it can be costly. You may need to get a special process server to do it, but you can generally serve notice on that tenant.
Okay, and does that document have to be notarized? Because I've seen two different 5-day notices, one with the notary block, one without the notary block.
No, the notice itself generally is not notarized. The affidavit of service would be notarized. So, for example, my client serves a 5-day notice, does not appear in court. Oftentimes the tenant will not come to court. Maybe they're embarrassed. Maybe they just, are going to be moving or what. They just don't come. There's a default. I will, then the landlord will get the affidavit of service notarized. He'll say that on June 5th, I served tenant X in the apartment, and then sign it, get it notarized. I will present the affidavit of service to the court, and the court would generally accept that. And so, yes, it does not need to be notarized. Sometimes the landlord or person who served the papers will actually come in court. They could be sworn in by the judge and say that, yes, I did serve the papers. The notarization, it kind of short circuits the process a little bit.
Got it. And so, okay, so we after 5 days, the tenant has not paid, then that document will be sent to you. Then after that, what is the next step? Let's walk through each specific step.
Sure. So step one, yes, they may actually, I recommend that they go to the lawyer for the preparation of the 5-day notice. I've seen some forms that are older than I am that are out there and it can be a little bit weak. Eviction law, the form can triumph substance sometimes. So you want to get certain things right, starting with the notice. So I would go to your attorney or have it preset as to the attorney's already told you how to fill out the form so you can do it, but make sure you get some consultation there. So anyway, a 5-day notice is prepared, signed. I always ask that for some tenants, ask them to sign a copy, bring two. Ask them to sign a copy. They're under no obligation to do that. But if they do sign it, it's kind of hard for them later to say, I didn't get the 5-day notice when you've got a signature on the 5-day notice that's theirs. But the 5-day notice is served. After 5 days, the landlord no longer need accept the rent. Within that 5 days, if the tenant offers you the full amount of the rent, the landlord must accept that. Or could not evict them for not paying,
and not a penny less, right? Because if they give you, if they owe $1,000 and they give you $200, then it's essentially like you're agreeing to that amount,
right? Now, unless it's in writing, most of the notice depends on what your notice says, which is again why I encourage you go to a lawyer to get the notice drafted. But if the notice says only full payment of the rent will stop the notice, unless the landlord agrees in writing otherwise. So if you say, hey, I can pay half now and I can pay half in 7 days, if the landlord agrees to it, it may be a good tenant. It may be a tenant that they really don't want to evict. It's just that the person has fallen behind maybe a couple too many times and they feel they have to serve the notice.
Right.
But they certainly are rooting for the tenant to catch up because they want that tenant to stay there. The tenant may be a model tenant as far as keep the apartment clean and everything else and never being a problem.
And another point that going back to the 5-day notice, I've seen the importance of adding the tenant's name and right after putting and all known and unknown occupants. Is that correct?
Yes.
Okay.
That's a key. Okay. Putting unknown occupants. I had a case once where it was all the way through the system and you don't want to get. Well, let me give you the ultimate horror story. The sheriff comes out to evict, and there's a person in the apartment who's not the person on the eviction notice. The sheriff will, if they have identification for that property, which many don't, but if they do, sheriff will walk away. Sheriff will not evict them because now they would have evicted them had the lawyer put on, John Smith and unknown occupants. Then you're covered. There can be 13 people in the unit. Doesn't matter. You do pay for a service fee to the sheriff of $60 for stating unknown occupants, but it's worth it. You don't want to get to the end of the case, or when the sheriff's out 3 months later, to find out that there's someone there that you didn't know about, and even if you didn't know about it, that's not a defense for you. If they're there, the sheriff is not going to put them out if they have identification for that property, unless you had unknown occupants on there. So that's very important to put on the lawsuit. So let's go over the papers if you don't mind. So after the 5-day notice, tenant hasn't paid in 5 days, then we draw up a complaint, a simple form complaint saying the facts that the tenant owes money. That complaint is filed. Of course, now we have the e-filing system, but you can get a court date 2 weeks later. So if you file on, so let's say you serve a 5-day notice on the 2nd, 3rd, 4th, 5th, 6th, 7th, they haven't paid. And the reason you're kind of tired of this tenant anyway, so you've got the lawyer ready, you've got the money ready, you're ready to go. So the 8th, you could file your case in court, and you can get a court date of the 22nd. So that's about as quickly as it can go. Now, if the sheriff does not serve the tenant with court papers, that they do not serve him the summons, then you have to get an additional court date.
So this is an ideal situation, right? You're saying that after the e-file has been submitted, a sheriff still has to go out and serve the
yes,
the court document. And I mean, I presume that they go out few days after?
It must be 7 days before the court date. So if you have a 14-day court date, they will go out probably only once within that court date. And if there's a building, which now very few buildings can a sheriff or anybody enter. In the old days, certainly you could go through the vestibule and knock on somebody's door. That's a rarity now. So if the sheriff rings the bell, Smith on 2W, and Smith doesn't answer the door, that's it. They walk away and say they couldn't serve them. So, and they probably only try once. So oftentimes the success rate with sheriff serving summons is less than 50%. More so in the suburbs with single family homes, but less in the city.
But they have to. The sheriff has to go out.
You must try.
And if they don't serve the tenant, then what happens next?
Then you can appoint a process server, or the court will routinely appoint a special process server.
But that court date is pushed back
2 more weeks. Then.
2 more weeks. Okay.
Yes, that's the quickest you can get.
So if the tenant is slick, they're not going to open their door.
Right.
And then if that process server now goes out and still cannot catch them, then what?
It is a problem. Now remember, I'll make sure the process server has a key to that, not to the tenant's entry door, but to the front door to the building. So they're not going to get stopped by ringing the doorbell and nobody answers. They're going to go enter the building. They're going to knock on that door. Probably the process servers, I haven't been there. I think they're fairly aggressive as far as they don't just gently knock. They cause a little bit of a commotion at times because they don't want to come back 3 or 4 times. Now, they'll come back, depends on your contract with them, so to speak, but they'll come back several times to serve that tenant.
Can I, as the property manager, meet with the process server or just be the eyes out for them and say, okay, well, I know that the tenant is here now. I know that you had a hard time coming by, last time. But I can confirm to you that they are here at this moment. Can you come by?
Certainly.
Is there communication with the owner or landlord?
Yes. If you have a good relationship with your process server, you won't have that with the sheriff. You can't call the sheriff and say, Joe's going to be there at 3:00. But you can do that with the process server. You can let them into the front door. Okay. And most process servers charge less than the sheriffs do. So it really works out well. To have that. So yes, the owner or the property manager that takes those steps with the process server will have a much better success rate. And as we know, time is money. We want that tenant out as quick as possible in order to get the property repaired, redecorated, rehabbed on occasion, depending on how bad the condition is, and then get a new paying tenant in the property.
And sorry, going back, can we not have the sheriff go out and just go directly to the process server?
No, not in evictions.
Not in eviction. Okay.
No, you must have the sheriff try first. And as I said, in large apartment buildings in the city of Chicago, the success rate is going to be less than 50%. If you're serving, I had a client who they were renting suburban homes. There, I would say it was more like 2/3 to 3/4 of the time the sheriff would serve the party, but not in the city. It's less likely.
Got it. So okay, we're looking at worst case scenario. Sheriff goes out, can't serve. Process server might go out a few times, and now once they finally serve the tenant, you're looking at probably within the court case will probably be another 7 days from that, approximately.
Right. Yes, that's a court date.
Right.
Now, when you file the case, the tenant will become popular with a lot of defense attorneys who will send them out a mailing saying, an eviction case has been filed against you. You may want us to represent you, which is perfectly legal for them to do that. And a number of tenants will get a attorney to file a jury demand, which will extend the case out a much longer time.
How long are we talking about?
I would say it would be a couple weeks to get assigned a judge. Most of the defense lawyers, though, will settle the case. Sometimes they'll want a fee to settle the case, which can irritate to no end some of your clients. Although sometimes the Chicago residential landlord-tenant ordinance has been violated by the landlord, and there may be a claim. But in general, the defense attorneys will allow for 45 days for the tenant to move. And if they move within that time, case is dismissed and it not go on their eviction record, so to speak. So you will not know. So I recommend to if people who are renting to people, it's not enough to look at the eviction record because it may not be there. Ask them for their last 3 months' rent. Because if they've been paying rent, or put it this way, if they've been in the eviction process, they're not likely paying rent. So even if it doesn't show up in the system, that the case is sealed and you wouldn't know. Right. But what they won't have is a quick pay statement from a bank saying, here's where I made my payments on time. So I definitely recommend that to landlords or property managers to ask for the rent receipt. That's amazing. What I go by more than just the public record.
Interesting. I thought that if they went through the courts, no matter what, you would have an eviction on credit. And you're saying that might not be the case if it goes to jury trial.
Even if it doesn't go to jury trial, part of the recommendation might be that the record is sealed.
So the judge's recommendation is what
well, I mean, the defense lawyer will know to write that. I mean, and this is a specialized defense bar. That's what they do. They defend people in eviction courts. So they will try to get the record sealed so there'll be no record of that eviction filing against that tenant. So another landlord might come to find out later that this person is not the best paying tenant and then say, well, gee, I didn't see any eviction filing.
Right.
There might have been several, but what they won't have are rent receipts.
Right. What about judgments? I mean, okay, they don't have that on credit, but what about the judgment amount? I mean, they still owed you, let's say they didn't pay 3 months. I mean, can you go after that amount on their credit? I mean, can you file a judgment for the $3,000?
Oh, I mean, the action for eviction is for back rent and for the order of eviction. So very often a judgment for a landlord will say if it's $1,500 a month, 2 months, judgment for eviction with a judgment for $3,000. And that can be collectible like any other judgment.
Right, but can that be put on their credit report?
Well, that would be picked up. That would be a public record. That wouldn't be sealed.
Okay.
But if it goes to judgment, that won't be sealed. And then, yes, that will show up on a credit report. So if they later try and buy a home or they later want to get a car or whatever, then yes, that will come up. And every now and then I will get a call. It's 4 years later. Right? Do you remember me? Well, I'm ready to pay off the judgment. Well, I know it's because they have bigger fish to fry, so to speak. Sure. And that's fine. And it works well for my client. We'll you pay up. We'll file the release of judgment gladly. We're happy to do that.
And then your firm you'll file the judgment as well. I mean, you'll go at okay, so you'll help with the eviction, but who goes after that $3,000 or who reports it to the credit?
Some lawyers are collection attorneys. Okay. I am not.
Okay.
I feel like my job is to get the apartment back to you as quick as I can, and I'm not so much worried about collecting. And by the way, you can get I've seen it, a big judgment. You try and collect, they're likely to file a Chapter 7 bankruptcy. So it's almost better to get the smaller judgment because they won't file for bankruptcy on that. But in any event, that's the way I practice. Now, other lawyers, they are more, if you're really interested in collecting, I would search for one that has that on their resume, so to speak.
I think most landlords kind of know that they may not get that. I think more than anything, they just want to ensure that judgment shows up on their credit report.
Yes, there can be some vindictiveness.
Yeah.
I like the joke is the person would like to see them dead and then pay money to me to write a book on what a bad tenant they were. Let's affect their legacy as well as their life.
Exactly.
But and it's understandable at that time. The landlord may be in jeopardy of losing their building because they can't make the mortgage payment because the tenant has not paid rent for several months. That they may have been very nice to the tenant and accepted a lot of excuses, and now it just gets worse and worse. The tenant may be causing problems. There may be leaks coming down into a paying tenant's apartment from a tenant's unit, and they're having trouble getting them out. At the same time, the tenant is causing damage to the building. So certainly I understand. And as an investor myself, I'm occasionally on that side of the fence where I've got a tenant that needs to be evicted. So that's certainly, I certainly understand how emotions can be raw in that type of situation.
Exactly. And so, so that's fine. So you don't go after the collection, but you'll still help putting the judgment on file.
Yes, the judgment it's one order.
Automatically
it's
on
one
file.
order.
There's
an order for eviction and a back amount. That's in the file. And then the judge usually gives them a stay of, even if they don't appear in court, even with a default, they normally get 7 days.
I see.
So then on day 8, then the lawyer would bring the papers to the sheriff saying, I'm placing this now for eviction. Everything before that is to get a judgment for eviction. Now I'm asking the sheriff to place the order for eviction, which is, additional monies, although not very expensive. You're just paying for the sheriff to come out and actually put them out. In the old days, they'd actually take the property out of the apartment. They don't do that anymore. They just get the person out of the apartment, and the landlord is supposed to make reasonable efforts to work with the tenant for the tenant to get their property out.
Understood. That makes sense. And and if there's any mishandling of that of the personal property after the fact, can that tenant come back and sue?
I suppose. In generally, if the landlord though is not acting in egregious manner, for example, they change the locks right in the middle of the eviction process or something like that.
I see. So
many things the landlords can do. By the way, the biggest problem you can avoid, do not take a security deposit. If you do, you will be very popular with the defense bar that will be representing the tenants. And if you can take a move-in fee, which is non-refundable, but I strongly recommend you'll save yourself a lot of anguish, and there's nothing more irritating than have a tenant be behind in rent, but you've collected a security deposit, which doesn't go near to cover the back rent they owed, and then you have a defense lawyer saying, I'll settle the case, waive the money amount, and by the way, pay me money as my attorney fee so that we won't proceed under the residential landlord-tenant ordinance because you commingled the security deposit. And by the way, the penalty for that is 2 times the amount of the security deposit plus legal fees. So it can be a large amount. You can avoid that. Don't take a security deposit.
There it is. Do not take a security deposit. I've mentioned that hundreds of times, and we finally have an attorney explaining the reasons why not to do that, and that is amazing. And now,
let me interrupt just for a minute, Jonathan, on that. I also recommend, although I haven't seen it in court, is the last month's rent. they'll say, oh, I won't take a security deposit. I'll just take last month's rent. The interest ordinance says you must pay interest on rents held more than 6 months. So if you collect January rent, when they move in, and December rent is the last month's rent, you can have a problem there. I see potentially. I can see a defense lawyer going after that by saying, this really was a security deposit, and you commingled it. So you're in the same boat as the other person. So what I have seen, I've done it myself, is if it's like 5 months, let's say it's January and May. You say, well, why would you do that? Well, I want to give this tenant a chance, and maybe the tenant doesn't have the best background, but I think whatever their issues were in the past, they don't have them now. Maybe they do have a better paying job now. Maybe they don't have maybe they were with a relationship with someone who's not with them anymore, and you think they're going to be more responsible. But you want to see a little bit more than the minimum, but don't go beyond 6 months, or at least that's my recommendation. I've not seen it litigated, but I would say you're safe if you don't have prepaid rent more than 6 months out.
Got it. Okay, well, that's fantastic. What about the fees involved for actually evictions? You said there's a sheriff fee, there's some filing fees. Regarding the county, what sort of fees are we looking at?
They've been, as you might imagine, they've been raising them. I remember a day when they were down to like $19 to file the case, but that was many, many, many years ago. Now you're talking, and as we said, you always name unknown occupants.
Okay,
that's very important. You don't have to, but it's really not prudent to not name them. You go by the number of people on the lease. So I've seen someone have like 4 people on the lease. Now, I'm not talking about minors. I'm talking about adults. And they may feel, well, I've got 4 people to collect against. Okay, but if there is an eviction, with 1 person and unknown occupants, it's going to be $500. That's the court fee plus the sheriff fee to go out the first time to serve them. Now, if you have like 3 extra people, or just add $60 per person beyond that. Figure $500 for 1 person and unknown occupants.
Okay.
Add $60 per person that you're naming after that.
That's okay. Okay. Got it. But not for minors, for anyone above
adults on the lease.
Okay, above 18. Got it. Okay. And that's it? Nothing else.
That's to file the case.
That's to file the case.
Now, if you don't serve them, which in the city expect them not to be served the first time out, then you must file an alias summons, which is not expensive. It's basically about $6 per person name. So for 1 person, unknown occupants, $12. So that's not that expensive. Eventually, let's say, and then of course you're going to have to pay your process server. Typically they're pretty reasonable. They're less than what the sheriff charges. And they don't just, if it's like 4 people, they're not likely to say, well, that's 4 services. That the sheriff started a while back. And
you get to choose your process server? You can just Google process server.
Right. You'd want one who's licensed. Certain judges will make you do that. I don't think the ordinance really makes you do that, but it's best to get someone who does it. But the good news is they'll know how to fill out papers. They'll know the process. They've done this before. Anyway, let's presume you pay them the fee. You finally get to court. You finally get the judgment. Then the sheriff's fee to put them out if the person has overstayed the time the judge has given them. So that's about $70 you have to get your order sealed and then bring it to the sheriff. So that's not that expensive. The bulk of the fees are with the initial filing fee.
Got it. Okay, so you're looking at, let's say 2 people, the individual plus unknown occupants. We're going to say that there's no one else there. You're probably looking at between $700 to $1,000. total, more or less.
You could be in filing fees, and then of course fees. you get to pay the lawyer.
Then the lawyer, right?
So now, and then some do it more than others, and it depends in part. Sometimes I won't take a case if I can see that this is going to be, I'll be in court forever.
Okay.
Or if it's a client that is just determined to ride that tenant down to the ground and get every last penny, I say, no, that's not for me. But if you want the tenant out quickly, I can give you a reasonable rate, but I'm really not a collection lawyer.
Right.
But yes, so fees vary, and it depends in part on what you want done. Now, it may be the case that you feel that the tenant has a lot of money and they've just spited you and you really want to go after them. Fine. Then you may want to be selective in who you want. Make sure the lawyer knows what you're expecting, because the last thing you want is the lawyer to think he's done his job when he's got the order of eviction, and you're acting like, though, that's just step one. What I really wanted was to garnish that person's wages, to basically cause them as much trouble as possible, to have their name spread far and wide in Cook County as someone to never rent to again. Sure. So you have to know what your client expects, and then are you willing to do it?
Got it. Okay, that's perfect to set up those in the initial conversation. Let the expectations be known right off the bat. So, okay, fantastic. Now, with what's going on today,
there are delays. Yes, there are delays in the whole system. You can't file and get
exactly.
Sheriffs aren't going to go out and serve.
Okay, you read my mind.
Cases are just being continued. And it's been frustrating. Say if someone filed a case before the moratorium took place, and now the cases are just being routinely continued for 45, 60 days at a time. That's very frustrating to a landlord, but that's the system we have right now. That we don't really know how things are going to shake out. There'll be more Zoom hearings and things, but when you get to contested cases, it's a little bit harder for courts to do that. For like in a probate case, I was just speaking with a judge who was saying, yes, here's the procedure, but it's uncontested. There's not going to be much of a problem. It's pretty clear where the rights are. In a landlord-tenant case, the judge won't know that. The defendant may, or the tenant may have a valid defense that they just don't expect in another type of case. Mm-hmm. So it's going to be something that we're going to have to work through. Hopefully the infection rates will go down and we can kind of get back to a, quote, normal.
Got it. So, we really focused a lot on the 5-day notice, the 30-day notice, the voluntary
yes, as I call it, eviction by right. Yes,
eviction
now,
by right.
That 30-day notice is often misunderstood.
Okay.
It's 30 days before the rent is due that you give them the notice. It's not like if most tenants' rent is due on the 1st of the month.
Right.
So you can't just give them the notice on the 10th of the month and say, okay, I can file on you the 10th of the next month. It's got to be, in that situation, if we take, for example, we're at the end of June, so this would be if you could properly give notices now, this would be a good time and say, I want you out by July 31st, because you're giving them 30 days notice prior to the rent being due. Notice, and it may make a difference what month you're in. July has 31 days. You could serve that notice on July 1st. I mean, in a normal period without eviction moratoriums on. But it's 30 days before the rent is due. So what I'll advise my clients is, if it's the 15th of the month, say it's May 15th, June 30th is what you tell them to be out by. Now, have I seen other notices? Yes, of course. And sometimes they get settled, and many cases don't go to hearing. The people work out an agreement. Even with a defective notice, you'll still get your eviction order. But it's good to go to the attorney first, just to try and get that notice properly done What you don't want to end up is spend the money, as we just noted. It's a lot of money to file the case.
Yeah.
You don't want to get your case dismissed for a bad notice.
Right.
When the tenant owes you money, and and the substance justice is on your side, but the notice wasn't, so you're not going to win.
And that's why, if you want to just do things right, reach out to Mike Bradley
or other lawyers who do the eviction process.
Sure, that's true too. But you've heard it here. I mean, he's given some great information. Mike, what is the best place that anyone can reach you if they want some more information?
My email address would be the best, and that's mwbradley. Bradley is BRADLEY 89@yahoo.com.
Perfect. Well, it's been a pleasure as always, and want to thank you so much for being on the show. Is there anything else that we may not have talked about regarding the eviction process?
That'll be for next show, Jonathan.
Okay, perfect. All right, so if you like what you heard, please hit that like button, subscribe to the channel, and thank you so much for tuning in. Take care.